So we're going to start the morning off with Equal Pay and Opportunities Act from L&I. We have Jackie Ferrer-Thomas and Devin West joining us today. Jackie is one of two equal pay agents with the Employment Standards Program at L&I. Her work experience includes state service for the past 10 years. Currently, Jackie administers the Equal Pay and Opportunities Act and enjoys serving the public and explaining rules and regulations. And then we have Devin Wesh, who's an equal pay agent at Department of L&I, with a background in criminal justice and a passion for equality, equity, and justice for those who have been treated unfairly. Today, Devin works towards educating employers, employees, and applicants regarding the equal pay requirements in Washington to help limit income disparities and reduce the number of children and families in poverty within the state. So thank you so much for joining us, ladies. I'll let you take it over from here.
Thank you so much for having us here today. We are very excited.
Yes, thank you, Corey. And so, yes, thank you for introducing us again. I'm Jackie Ferrer-Thomas, and yes, I am the Equal Pay Agent with L&I's Employment Standards Program. Okay, and so my coworker Devin is who spoke earlier this morning, and so we'll just go ahead and get started. Today we'll be talking about the Washington's Equal Pay and Opportunities Act. We welcome your questions after the presentation. Here's the plan for today's presentation. We will share an overview of the Equal Pay and Opportunities Act, as well as employee and job applicant protections under this act, including recent pay transparency and job posting requirements, which took effect on January 1st, 2023. We will also go over our enforcement and investigation process, and we'll provide you with recommendations and additional resources so you can confirm your organization's compliance with the law. L&I has the authority to enforce the Equal Pay and Opportunities Act, RCW 4958, which took effect on June 7, 2018, and updated the Washington Equal Pay Act of 1943, RCW 4912-175. The legislature's intent was to address income disparities, employer discrimination, retaliation practices, and to reflect the equal status of all workers in Washington state. This law promotes gender pay equity through equal pay, equal career advancement opportunities, open wage discussions, and prohibited retaliation against employees. As of July 28, 2019, the legislature took additional steps towards gender equality and added more protections for employees and job applicants to this law. Additional protections were afforded to employees and applicants as of January 1st, 2023. Under this law, all employers doing business in Washington are required to comply with the Equal Pay and Opportunities Act, including private and public employers. All employees working in Washington are protected by the law. All applicants seeking employment with a Washington employer are protected by the law. Equal Pay and Opportunities Act, EPOA, prohibits gender pay discrimination and promotes fairness among workers by addressing business practices that contribute to income disparities between genders. Both employees and job applicants have rights under this law. Employees have the following rights under EPOA: equal pay not based on gender, equal career advancement opportunities not based on gender, ability to discuss wages with others, protection from retaliation for exercising their rights under the law. And for employers with 15 or more employees, access to salary range information of a new position or promotion upon request by the employee, access to wage scale or salary range, benefits, and other compensation on an internal job posting. Job applicants have the following rights under the law: wage and salary history privacy, protection from wage and salary history requirements, access to wage scale or salary range, benefits, and other compensation on a job posting. Employers with fewer than 15 employees do not have to meet this requirement. Let's go over employee rights in more detail. Employees have the right to equal pay. Employers may not discriminate by providing different compensation based on gender between similarly employed employees. For purposes of the Equal Pay and Opportunities Act, employees are similarly employed if they work for the same employer and the performance of their job requires similar skill, similar effort, similar responsibility, and similar working conditions. Skills include factors such as experience, training, education, and abilities required to perform the job. It must be measured in terms of the performance requirements of the job, not in terms of the skills an employee happens to have. Skills not necessary to perform a particular job are not relevant to determining whether jobs are substantially similar. Effort is the amount of physical or mental exertion needed to perform a job. Factors the job which cause mental fatigue and stress, as well as those that alleviate fatigue, should be taken into account. Effort encompasses the requirements of the job as a whole. Responsibility includes the degree of discretion or accountability involved in performing the essential functions of the job, as well as the duties regularly required to be performed for the job. This includes factors such as the amount of supervision the employee receives or whether the employee supervises others. It also includes the degree to which the employee is involved in decision-making, such as determining policy, procedures, purchases, investments, or other such activities. Working conditions include factors such as the physical surroundings and hazards encountered by the employees performing the job. Job titles alone do not determine if employees are similarly employed. Employers need to consider the overall compensation given to employees to confirm their compliance with the equal pay requirements. Compensation includes wages and benefits provided by an employer to an employee. Wages include, but are not limited to, salaries, hourly rates, commissions, and non-discretionary bonuses. Benefits include compensation given to employees, not based on performance, such as gifts, medical insurance plans, retirement plans, paid time off, and discretionary bonuses. Employees who are similarly employed could be compensated differently, as long as the difference is based entirely on permissible, bona fide, job-related factors that are consistent with business need, are not based on gender, and account for the entire compensation difference. According to the law, permissible job-related factors include, but are not limited to, education, training, experience, a seniority system, a merit system or performance, a system that measures earnings by quantity or quality of production, regional differences in compensation levels, and compensation based in good faith on a local minimum wage ordinance that is different from state law. It is very important you maintain good records so you can defend your side of the issue in case we get a complaint filed against your organization. For instance, if you're determining compensation given to your employees based on job performance, maintain all records related to job performance, including disciplinary notes or any other information you took into account when you determine your employees' compensation. There are several unacceptable reasons for pay differences. Gender cannot be the reason for pay differences between employees with similar jobs. An employee's previous wage or salary history is not an acceptable defense for compensation differences. Pay negotiation at the time of hire is not an acceptable defense for gender pay differences. Employers can negotiate pay during the hiring process, but if the pay offered to a new employee causes a gender pay difference between similarly employed employees, any difference in compensation must be based on justifiable job-related factors, not the negotiation itself. Employers carry the burden of proof to justify why compensation differences exist. In Washington, you're not required to conduct an equal pay analysis. However, we do recommend that you conduct a self-evaluation of your organization at least once a year. I would also recommend you review your employment policies to make sure you are in compliance with all of the Equal Pay and Opportunities Act requirements. Next, we'll go over a recommended process for you to conduct an equal pay evaluation of your own organization. This process should be used only as a starting point to determine whether employees performing comparable work are paid equally. Step 1, assess work of similarly employed employees. Step 2, analyze compensation. Step 3, apply bona fide factors. Step 4, correct unexplained differences. Next, we'll go over each of those steps in more detail. The first step to determine your compliance with equal pay requirements is to assess work of similarly employed employees. So determine which employees are performing similar work. Employees are similarly employed if they work for the same employer and the performance of their job requires similar skills, similar effort, similar responsibility, and similar working conditions, regardless of job descriptions or job titles. If you find that your employees are not performing similar work, or if you don't have a group of employees that would be considered to be similarly employed, your analysis ends here. Step 2, analyze compensation. If you find that you do in fact have employees of different genders that will be considered to be similarly employed or perform similar work, you will need to include them in the same job group when conducting your equal pay analysis. Are employees of different genders who perform similar work being compensated equally? Remember, we do need to account for the overall compensation given to employees. Compensation means the wages and benefits provided by an employer to an employee. Wages include, but are not limited to, salaries, hourly rates, commissions, and non-discretionary bonuses. Benefits include compensation given to employees not based on performance, such as gifts, medical insurance plans, retirement plans, paid time off, and discretionary bonuses. For an organization with small, clearly defined groups of comparable jobs and relatively simple pay structures, a simple analysis comparing the average wages earned by all genders of similarly employed employees working in comparable jobs may be sufficient to identify whether there are disparities. When a number of employees in a particular job group or comparable job exceeds 30, or the pay structure is complex, a more detailed analysis is likely necessary. You should consult with an attorney about your options and what method of analysis is more appropriate for your organization. Step 3, apply bona fide factors. If there are differences in compensation between employees of different genders performing similar work, you should ask yourself, what is the reason for the pay differential? Compensation differentials are permissible when the difference is based on bona fide factors: education, training, or experience, a seniority system, a merit system, job performance, a system measuring earnings by quantity or quality of production, regional differences in compensation levels, local government ordinance requiring higher minimum wage, pay differences not based on permissible bona fide factors are potential for a violation when gender pay discrimination is alleged. Step 4, correct unexplained differences. Employers are recommended to take proactive steps to correct any pay differences between employees of different genders performing comparable work that are not justified by one or more of the permissible factors listed in the law. In most cases, where corrections are necessary, pay adjustments are recommended for some or all employees within a comparable job group. If pay differences are not justified by a bona fide factor, employees who are not compensated highly enough should be brought up to the appropriate salary level. Employers should develop and implement a remedial plan as soon as possible upon completion of the self-evaluation. You also need to make sure that your remedial plan is in compliance with this law and other wage and hour laws. Now, Devin will talk about equal career advancement opportunities.
Thank you, Jackie. Equal career advancement opportunities is another right that employees have under this law. An employer may not limit or deprive an employee of career advancement opportunities that would otherwise be available based on gender. Career advancement opportunities are determined on a case-by-case basis. Career advancement opportunities could include promotion opportunities or job-related training. Differences in career advancement opportunities between genders may be acceptable as long as the difference is based entirely on job-related factors that are consistent with business need, are not based on gender, and account for the entire differential. Permissible bona fide factors include, but are not limited to, education, training, or experience, seniority, the merit system or work performance, and measuring earnings by quantity or quality of production. Open wage discussions. Employees may not be prohibited from discussing, comparing, or disclosing their wages as a condition of employment. Employees may not be required to sign waivers or other documents that prevent them from disclosing their wages. Employees are not required to disclose their wages if asked. Usually, the clearest violations entail employment policies where employees are informed that wage discussions are prohibited. This could be because employers were not aware of this protection, or they just forgot to update their policies. Employers can prohibit such disclosures if an employee has access to compensation information of other employees and applicants as part of that employee's essential job function, such as a human resources manager. These employees still maintain the right to discuss their own wages and are also protected from retaliation. Access to wage or salary information is another protection that employees have under this law. Employers must provide an employee who is offered an internal transfer or promotion with the wage scale or salary range of the new position after the position is offered and upon request by the employee. Employers with fewer than 15 employees do not have to meet this requirement. Employees are protected from retaliation if they are exercising any of their protected rights under the law. Additionally, an employer may not retaliate, discharge, or discriminate against an employee because the employee was asking the employer to provide a reason for their wages or lack of opportunity for advancement, inquiring about, disclosing, comparing, or discussing their wages or the wages of another employee, encouraging another employee to exercise their rights under the law, or filing a complaint or exercising any other protected rights under the law. Now let's talk about job applicant protections. The first protection is wage and salary history privacy. Employers cannot seek the wage or salary history of an applicant. An employer may confirm an applicant's prior salary after the employer negotiates and makes an offer of employment, including pay, to the applicant and the applicant accepts the offer. Job applications cannot ask for an applicant's previous salary, even if that section is not required or is optional. Employees can voluntarily disclose their wage or salary history to prospective employers. There's also the protection from wage and salary history requirements. Employers cannot require that an applicant's prior wage or salary history meets certain criteria or require that an applicant made a minimum amount previously in order to be considered for the new position. Applicants also have the right to have access to wage scale or salary range information. Employers must provide on a job posting the entire wage scale or salary range of the position being advertised, as well as a general description of benefits and other compensation available for that position. This last requirement only applies to employers with 15 or more employees. Here are the rights that employees and job applicants have under this law, RCW 4958-110. The previous protections are that upon request of an applicant or employee for employment, after the employer has initially offered the position, the employer must provide the minimum wage or salary for the position for which the applicant is applying. Effective January 1st of this year, job applicants and employees were provided further protections as follows. Upon request of an employee offered an internal transfer to a new position or promotion, the employer must provide the wage scale or salary range for the employee's new position. Access to wage or salary range, general description of benefits and other compensation on job postings. These apply to employers with 15 or more employees. RCW 4958-110 discusses disclosure of wage or salary range by employer. An employer is required to disclose wage scale or salary range for employees undergoing a transfer or promotion upon request of the employee. These instances include, but are not limited to, demotions, reversions, reallocations, acting appointments, reemployment, or in-training appointments. So what did ESSB 5761 change? Again, beginning January 1st of this year, all employers with 15 or more employees engaging in any business, industry, profession, or activity in Washington must disclose wage and salary information and the general description of all benefits and other compensation on job postings that recruit Washington-based employees. It is important to note this only applies to postings that meet the definition of a posting. A posting, as defined by ESSB 5761, is any solicitation intended to recruit job applicants for a specific available position, including recruitment done directly by an employer or indirectly through a third party, and includes any postings done electronically or with a printed hard copy that includes qualifications for desired applicants. If these elements of a job posting are not met, the employer is not subject to the job posting pay transparency requirements. Here are a few examples of what a job posting may look like. The first example of an electronic reader board outside of a business includes a qualification of a food handler certification and references a specific position of server. For the second example of a social media post, the employer is advertising for a specific available position, including qualifications, on the social media post. In this last example of an online posting, the employer is advertising for a specific available position, including qualifications, on an online job board or web-based application. As a reminder, if the elements of a job posting are not met, the employer is not subject to the job posting pay transparency requirements. The following examples are not considered a job posting per ESSB 5761. The first example of a help wanted sign is missing qualifications and a specific position. The second example of a website banner does not reference a specific position. And the third example of a social media post also does not include qualifications or a specific position. Now that we know what a posting is, we can go over what is required in those postings as of January 1st. Employers are required to include a wage scale or salary range. This is the employer's most reasonable and genuinely expected range of compensation for the job. Here are some examples of what that can look like in hourly wages, yearly wages, and a salary based on commission. Also included in the requirements is a general description of benefits and other compensation. Things that a general description of all benefits includes, but is not limited to, are healthcare benefits, retirement benefits, and any benefits permitting paid days off, including more generous paid sick leave accruals, parental leave, and paid time off or vacation benefits. Such a description may look like this. Employees and their families are covered by medical, dental, vision, and basic life insurance. Employees are able to enroll in our company's 401k plan, as well as a deferred compensation plan. Employees will also receive 8 hours of vacation leave every month and 12 paid holidays throughout the calendar year. Other compensation includes, but is not limited to, any bonuses, either discretionary or non-discretionary, stock options, tuition reimbursements, sign-on bonuses, or other forms of compensation, such as tips, that could be offered to the hired applicant in addition to their established salary range or wage scale. An example would look like this. Hired applicant will be able to purchase company stock, receive annual bonuses, and participate in profit sharing. Employment Standards has published an administrative policy to provide additional guidance on what employers are required to disclose in job postings. The administrative policy has been posted on LNI's website. A job posting requirements fact sheet was also created to assist employers with understanding what constitutes a job posting, the information required on job postings, and to offer examples of job postings that would meet the requirements. We'll go back to Jackie now to go over some of our most commonly asked questions.
Thank you, Devin. So here we have one of our most commonly asked questions. Which employers must disclose a wage scale or salary range and a general description of benefits and other compensation on a job posting? All employers with 15 or more employees engaging in any business, industry, profession, or activity in Washington must disclose a wage scale or salary range and a general description of benefits and other compensation on job postings that recruit Washington-based employees. Next commonly asked question. Do the 15 or more employees threshold include employees working out of state? The answer is yes. The 15 or more employees threshold includes employees that do not have a physical presence in Washington if the employer has one or more Washington-based employees. Please refer to ESA 13 Minimum Wage Act Washington-based employee for a description of the factors the department applies to determine whether an employee has Washington-based employees. If an employer's number of employees fluctuates above and below the 15 employee threshold throughout the year, do they need to comply with these requirements all year? Whether the employer will need to comply with the pay transparency law will depend on the number of employees they have when the job is posted. An employer may choose to assume the law applies rather than changing their practices for each fluctuation, but the employer is not required to do so. Another commonly asked question. Do employers need to include wage or salary range information on nationwide postings? There are a couple of different circumstances that will fall under this question. Employers must disclose a wage scale or salary range and a general description of benefits and other compensation on job postings if the posting is for a position that could be filled by a Washington-based employee, including remote work that could be performed by a Washington-based employee. An employer cannot avoid disclosing wage and salary information requirements by indicating within a posting that the employer will not accept Washington applicants. Employers do not need to disclose wage and salary information for jobs to be performed entirely outside of Washington, even if the job posting reaches applicants who will fill the position as a Washington-based employee. The out-of-state exception applies to jobs tied to work sites physically located entirely outside of Washington. This out-of-state exception is applied narrowly on a case-by-case basis. What if we only pay a flat rate for a position, such as minimum wage? The law requires employers to provide a wage scale or salary range. LNI suggests that employers are as transparent as possible on their job postings. Employers should create the full range of compensation for a job before they post a job posting and consider possible pay changes based on factors such as performance, qualifications, seniority. To sum up, a flat rate is not complying with the requirements of this law, and a scale range must be provided. If an employer does not already have an existing wage scale or salary range for a position, a scale or range should be created prior to publishing the posting. Who is considered an applicant under the Equal Pay and Opportunities Act? All applicants, including existing employees who apply to a posting recruiting Washington-based employees, with an employer as defined as RCW 4958-010, including employers who may not have a physical presence or employee in Washington state, are protected by the law. A person is only considered an applicant for the specific position they apply for, not for every available job of the employer. LNI will investigate complaints filed only by applicants who have applied to jobs in good faith with the intent of gaining employment. Do employers need to provide a wage and salary information to employees undergoing internal movements between positions, such as promotions, voluntary, involuntary demotion, reversion, reallocations, and training appointments, non-permanent appointments? The answer is yes. Movement between positions, including these examples, will likely be considered internal transfers and thus be subject to the disclosure of the wage scale or salary range upon request of the employee. What if I only intend to hire at a specific starting range? If an employer intends to implement a starting range or starting rate for an internal timeframe of employment or probationary period, the starting range or rate may be listed on the posting, but the entire scale or range must also be listed on the posting. As a reminder, if an employer does not already have an existing wage scale or salary range for a position, a scale or range should be created prior to publishing the posting. Can electronic postings link to benefits and other compensation information? On electronic job postings, an employer must include a general description of benefits and other compensation, but may choose to utilize a link or hyperlink to lead the applicant to more detailed description. It is the employer's responsibility to assure continuous compliance with functionality of links, up-to-date information, and information that applies to the specific job posting, regardless of any use of third-party administrators. And our final commonly asked question is an employer liable if their job posting is reposted by a third party on its own initiative without being instructed? The answer is, the Act covers only posts an employer itself makes or has another party make. An employer is not liable if they have a compliant job posting, but then a third party on its own initiative, without being instructed or hired by the employer to do so, reposts that employer's job without the required information. Now that we're gone, so some of our most commonly asked questions, Devin will talk about our investigation process. Take it up.
Thank you, Jackie. If an employee or a job applicant files a complaint, LNI must investigate it. During an investigation, LNI may request documentation and witness testimonies. Employers carry the burden of proof to justify why compensation differences exist. If violations are not found during an investigation, LNI will send a notice of finding to the complainant and employer along with the agent's report. At that time, LNI will close the investigation. If LNI investigates a complaint and finds a violation of the Equal Pay and Opportunities Act, LNI must attempt to resolve the complaint through conference and conciliation. Participation in conference and conciliation is voluntary for the claimant and the employer. The goals of conference and conciliation are to try to resolve the complaint without issuing a citation and notice of assessment to the employer, as well as reaching a resolution that is acceptable to the claimant, the employer, and LNI. Possible resolutions may include paying damages, including back wages owed, revising company policies, job reinstatement, or other proposed resolutions. If violations are not resolved through conference and conciliation, LNI may issue a citation and notice of assessment and order the employer to pay actual damages, statutory damages equal to the actual damages, or $5,000, whichever is greater, interest of 1% per month on compensation owed, investigation and enforcement costs, a civil penalty of $500 for a first-time violation, and $1,000 or 10% of damages, whichever is greater, for repeat violations. Employers have the right to appeal a citation and notice of assessment if they do not agree with LNI's findings. An employee may bring a civil action against an employer within 3 years of the date of the alleged violation. If an employee files a civil claim in court, L&I cannot investigate a complaint filed with the department. Regardless of whether or not L&I has made a determination, a claimant may still pursue civil action. Here, we have a list of resources that are available to you. We have created a web page with commonly asked questions and have several quick guides available to make navigating the requirements as simple as possible. We mentioned a self-evaluation earlier. The EPOA Employer Resources page listed here includes some helpful resources to assist you in completing that self-evaluation and confirming your organization's compliance with the law. Employers are encouraged to request a voluntary consultation with the Washington State Department of Labor and Industries to increase their understanding of the law. A consultation will provide an educational opportunity and an informed assessment of possible risks specific to your individual organization, as well as proposing resolutions to assist with future compliance with the law. You can request a comprehensive review of your organization's policies and practices, or you can request information about a specific concern. EPOA consultation benefits for the employer include that no penalties or assessments will be issued if potential violations are identified, so long as there are no active EPOA complaints filed against your organization during the course of the consultation. You will receive recommendations to comply with EPOA requirements and to prevent gender pay discrimination, including equal pay, equal career advancement opportunities, and hiring practices. You will have the chance to learn how to add clarity and transparency to your policies and practices regarding EPOA protections and reduce potential risks of having EPOA complaints filed against your organization. Some of what L&I will provide during a consultation includes a review of your employee handbook, policies, job applications, offer letters, non-disclosure agreements, and other documents, identify potential risks, explain EPOA requirements and protections, and recommend revisions to policies and practices. Our program provides the following language access services at no cost to our customers, including phone and in-person interpretation, translations for documents during audits, consultations, and investigations, and interpretation during webinars when requested in advance. For any questions, you can contact our Access Coordinator, Luz Gonzalez-Virgen. Customers can contact L&I's Civil Rights Program to report if L&I staff failed to provide language access services. As always, the information provided in this presentation does not and is not intended to constitute legal, business, or regulatory advice. Instead, all information, content, and materials presented are for general informational purposes only. We do not make any express or implied guarantees based on the content in this presentation. While we make efforts to keep the information in this presentation current and accurate, please note that there may be delays between official publication of materials and the modification of the content in this presentation. This concludes our presentation today. We hope that you found this information helpful. We are happy to answer any questions you may have. And if you have a question that we do not have the answer to right now, please send us an email and we will follow up with the best answer that we can provide.
Devin, we have a couple questions online. I'll read those first, or actually it looks like Jackie sent a couple links.
Yes, I posted the job fact sheet so that it describes more what our job posting is and our L&I policy in regards to the transparency law that passed in January 1st.
Perfect. And then we have our medical benefits structured where we only partially pay the premium for spouses and dependents. Is this considered to be a form of discrimination?
Okay, so you have the medical benefits structured in such a way that you only partially pay for spouses and dependents.
Mm-hmm.
So that is not something that would be covered by our specific program area, but I don't believe that that would be considered a form of discrimination. But again, it's not covered by our program area. So someone else might be a better person to answer that particular question.
Right.
Just because that's not covered by the law, this law.
Okay. Any questions in the room? Well, it doesn't seem like we have any questions in the room. Thank you so much. Will you guys be able to share your presentation so we have live links to share with the participants?
We will send you a copy of our presentation, absolutely.
Okay, wonderful. Thank you so much, you guys.
Thank you.
Thank you,
for having
Corey. Yes.